Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would look today into the new form of targeted economic sanctions, which were used by the United States, presumably for the first time in history, the introduction of tariffs for the purpose of exercising sanctions pressure on the third-party jurisdictions. There was a recent occasion to discuss this matter. The relevant tariffs became effective on the 27th of August. And it's a good opportunity for us to consider this new tool of international economic sanctions, its lawfulness as an act itself, and its efficiency in the context of the general sanctions program pursued by Western countries against Russia. So what we'll discuss today is the following 4 points. We'll first of all summarize the main elements of executive order, which was published early August, whereby the relevant additional tariffs on Indian products were announced by the US administration. Then we would discuss the background to the matters which led to the adoption of this order. We would discuss both the context of Indian-US trade and the way it will be affected by the order, as well as the trade in Russian crude oil by India, which was, as it was alleged, the cause of adopting the order. And then we would discuss 2 main points to bring this matter into the context of our series, Sanctions 360s, as there were plenty interviews and analysis of the matter from the economic perspective, but we focus on this in the context of international economic sanctions. And what is of interest for us is, first of all, the consideration whether the exercise of these powers for the purpose of imposing economic sanctions on third-party jurisdictions is indeed the lawful exercise of powers, or try to think about what may be the potential arguments of various plaintiffs which are already challenging similar type of measures taken by President Trump. And then we would consider and conclude by the main point of this presentation, which is how these tariffs fit into the overall sanctions efforts of the Western coalition against Russia in the context of its trade of crude oil and petroleum products. So let us begin by summarizing the main elements of the executive order. It was adopted by President Trump using his executive powers granted by Congress, primarily under the International Emergency Economic Powers Act. And this act, in essence, allows the US president to take restrictive measures with respect to the domestic national emergencies which are caused by extraordinary situations abroad. So the extraordinary situation abroad, which was identified by President Trump for the purpose of adopting this order, is the existing war in Ukraine, the cause for adopting various other executive orders by the existing US presidents and his predecessors. And in effect, this order is not identifying any kind of new national emergency, but is referring to the continuous war in Ukraine and the need to take additional measures to address that situation. So to address that situation, the president decided to impose additional tariffs on a third-party country, which by itself is not directly, or at least there is no evidence of being directly involved in the military conflict on the side of any party. This third party being India, which in accordance with the order is punished for purchasing Russian oil and oil products. And the specific person who is identified as being the purchaser of those oil products and crude oil itself is the government of India. So for that reason, an additional tariff of 25% is imposed on certain categories of Indian exports into the United States, and the relevant measures became effective on the 27th of August this year. So let's put these measures into the context of the general trade of India in Russian crude and its trade relationship with the United States, so that we see a little bit better the picture, which is the background to these legal acts. India has historically been largely importing its oil from the Middle East, which is geographically the closest region to India. But starting from 2022, when the European Union, the United States, and other Western coalition partners decided to reduce the consumption of Russian oil and oil products and gradually introduced what is now known as an embargo on Russian oil and oil products, meaning that in general, except for a limited number of exemptions, for example, oil flowing by Southern Druzhba pipeline into the European Union, the relevant jurisdictions are not purchasing Russian oil and oil products anymore. Having said this, the European Union specifically is certainly the net importer of oil and oil products. And what it meant in practice is that it reoriented its supply chain from Russia, which is its closest geographical partner, to Middle East. When that decision was made, given the substantial imports of Russian oil and oil products into the European Union, certainly the view was need to be taken how this supply will be rebalanced on a global scale. And it is at that moment of time that India reoriented its supplies from the Middle East, which started to supply now oil to the European market, to Russia, and starting from 2022, consistently increased these supplies, which currently account for approximately 40% of Indian imports of Russian oil. Having said this, India is not the biggest purchaser of Russian crude. The biggest purchaser is China, and India and China are not the only purchasers of Russian crude. There are many other countries which continue to purchase Russian oil or oil products, including Turkey, including countries in the Middle East, which are purchasing mostly oil products. Some supplies of oil products go to Latin America, and etc. Surprisingly, even the United States continue to purchase petroleum products from India, as 40% of Indian imports of oil comes from Russia. By way of analogy, a substantial part of those petroleum products are actually refined from Russian crude oil. The volume is substantial, as India is a large economy. We talk about 1.8 approximately million barrels of oil per day, and that's a substantial part of overall oil trade, as well as Russian trade, which is approximately 7 million barrels per day. It's also important to note that the purchases of Russian oil in India is not actually the government of India or state-owned enterprises. Most of these purchases are actually made by privately held enterprises in India. So there is in fairness, objectively speaking, limiting what India can do in terms of restricting these enterprises of managing their matters in the way they want to manage, except for taking that political decision of embracing sanctions against Russia in one form or another. On the other side, the trade between India and the United States is an important part for Indian economy. It accounts for approximately 18% of total Indian exports, and the overall amount is coming close to $90 billion per year. India runs generally a trade surplus with trade with the United States, which is coming to approximately, we can see on this graph, to 4 billions per month, or approximately 48-50 billions per year. So US is a substantial and a very important trading partner for India, and the proposed tariffs will affect approximately 55% of the relevant trade. Some items will be more affected than the others. Most effective will be textile and apparels production industries, which in India are largely small and medium-sized enterprises, will be very badly affected by the tariffs. Jewelry industry will be affected, seafood and metals production industry as well. Conversely, the industries which are important for the US economy, like pharmaceuticals, production of electronics goods, services, and again, to some extent surprisingly in the context of this discussion, continuous purchase of refined oil products from India will be subject to very limited impact, if any impact at all, from the newly introduced tariffs. So now we will try to bring this overall picture and decision into the context of the sanctions theme of our theories. And we will try to consider 2 points. The first one is the lawfulness of the measure itself, which is the matter of US law, of course. And the second is the overall appropriateness of this matter given the general Western sanctions program with respect to Russian crude and petroleum products. As to the first point, these tariffs are certainly not the first tariffs introduced by President Trump. Starting from his very early days of second term, international politics has been largely focused on tariffs, although those tariffs were not directly related to any sanctions programs and regimes, but were more aimed at reducing the trade deficit of the United States with other jurisdictions. So many of those are already subject to judicial review within various court proceedings in the United States, and the general challenges can be summarized as falling into the following 3 categories. One category of arguments tries to challenge the technical aspects of the US president using his powers under the International Economic Emergency Powers Act, meaning that either the president failed to identify adequately the national emergency, which has to be addressed by the relevant powers, or the means which the president chose to address that emergency are not efficient or are not directly linked to it. In the case at hand, it seems that these arguments have limited chances to succeed. The primary reason being certainly the discretion of the US president to identify the national emergency and to choose the measures which would be adequate to address the emergency. But the second reason is also a substantive point. Certainly the national emergency which was identified by the US president, as well as the means of pressing third-party jurisdictions which presumably supply substantial income to Russia, is hardly an appropriate means to achieve that objective. So it seems that at least with respect to these type of tariffs, this type of technical arguments are unlikely to be successful when trying to challenge the relevant tariffs. However, the second argument, which in essence is based on the point that the US president exceeded his powers granted by the act to adopt tariffs in the first place, so he has no powers to adopt tariffs, seems to have more grounds for success because indeed the relevant powers of the president in the act are very carefully enumerated, and they largely relate to imposing blocking sanctions or restrictions on payments, the type of measures which have been historically used by the US president when adopting sanctions programs against general jurisdictions. There is no provision of the act which deals with the imposition of tariffs, duties, or excises with respect to trade with third parties. And in this sense, it may very well be argued that the powers used by the president in this specific case were not granted to him by the relevant act, and for that reason, he exceeded the delegation of powers granted by the act. If this argument is not successful, there is also a broader point of the separation of powers and whether the act then in itself is constitutional, because the broad delegation of powers which occurred to the US president with respect to the imposition of tariffs by Congress, which is the original source for imposing taxes, tariffs, excises, and duties under the US Constitution, is arguably unconstitutional because no checks and balances are set forth in the act which would traditionally be envisaged for any type of similar delegation of powers to the executive branch. Whether any of these arguments are successful is to be seen relatively shortly. Having said this, the whole idea of using tariffs as the sanctions seems to have no firm or at least dubious legal basis in the US constitutional law. What is also relevant for us is to consider how these measures fit into the overall sanctions program of the West towards Russian crude and oil products trade. When these measures were discussed in the first time in 2022, the overall basis of trying to restrict Russian trade in oil compared to, for example, other natural resources such as coal, for example, or gold or diamonds, was that the supply of Russian crude and oil products to international markets is critical for overall balance of prices and volume of supply. We discussed this matter in more details in our presentation with respect to the sanctions imposed to regulate Russian crude and oil products, which I will not repeat here, but by way of summary, the overall conclusion was that it's impossible to impose overall worldwide restrictions on the purchase of Russian oil because this will create imbalance of demand and supply in the product, an unpredictable change in the prices. And for that reason, a so-called oil price cap targeted sanctions were developed, whereby Russia shall be able to supply its crude to international markets, provided that this supply happens at or below a certain price cap, which is set by the price cap coalitions, and which is set at a certain discount to the market price. So the idea is to maintain the supply of Russian crude, and by doing so, maintain stability of oil prices, but at the same time, try to reduce Russian revenues from this trade. And indeed, the Prime Minister of India, the Foreign Minister of India, in one of his interviews on the matter, clearly confirmed that at the time when the Western countries introduced oil embargo on trading Russian crude and oil products, discussions were held with India, and in essence, India agreed to absorb this additional supply of Russian crude so that to ensure the overall balance of the prices. In this respect, it has never been intended that India will stop buying Russian crude oil products at all. It is noteworthy in this sense that the executive order, which was published by the US administration does not refer to oil price cap at all. The executive order is not saying that the tariffs are imposed in India because it allegedly purchases Russian crude above the oil price cap. The tariffs are imposed for India purchasing Russian crude at any price whatsoever. This seems to be in clear inconsistency with, first of all, the overall policy of oil price cap-based targeted sanctions, as well as previous arrangements which were made with India on this matter. Now let's assume, for the sake of argument, that India renounces the purchases of Russian crude. As we already discussed, this is substantial volume of 1.8 approximately million barrels per day. There is no spare capacity which is able to produce this amount of crude overnight, and it's doubtful if there is any spare capacity which is capable of produce this crude oil even within the midterm scenario. Any such measure is certainly likely to cause a substantial imbalance of the markets and the subsequent increase of prices, with the net result being that even if Russia, for example, does not find a purchaser for this volume of crude, then the reduced volume sold at a higher price may eventually result in even higher revenues being generated by this trade. So it seems that the measures taken in this executive order are not only inconsistent with the ALA agreement which the coalition had with India, but it also has very uncertain and unpredictable effect on the overall purpose of the alleged measures which were introduced by the US administration. Thank you very much for watching, and I trust to see you during my next presentations.